All right, I think we're live. We're going to give it a few minutes for people to join this particular conversation, but I think it's just 0 people at the moment, Roman, but we'll wait.
Great. Give folks
All
a couple
right.
minutes.
So we'll give it like a few minutes, but for any of you who are now tuning in, welcome and thank you for coming. So today's conversation or podcast is called the H-1B policy update and how it will impact HR leaders and global mobility specialists. So I think we have a lot to talk about today, given like the recent news and everything that's going on. But I have here also with me Roman Zelichenko, if you want to kind of give yourself a little bit of a spiel, and then we can talk whenever we're ready to start the conversation.
Sure, yeah. Hey, everybody. Roman Zelichenko. I am a former immigration lawyer focused primarily on H-1Bs when I did practice. Now I run a company called Laborless, which does H-1B compliance automation. So this is my whole world, which has been turned slightly upside down. Hopefully, eventually, we'll be right side up. So excited to talk to you about everything that's been going on with the fee, wage proposals, et cetera, and obviously how it may or may not ultimately impact our industry and the folks who work at H-1B employers, immigration, mobility specialists, low mobility folks, et cetera.
So just as a reminder for everyone who's tuning in, there is going to be a portion where we may be able to answer some questions out there. Just note that anything that we say is not necessarily specific legal advice. It doesn't establish an attorney-client relationship between either of us and you. And also separately, when you do post any questions that are sent to us or like provided in like any chat functions, remember that these are public. We're also going to be recording this particular podcast. So anything that you want to share that's confidential, probably don't want to put it in that chat. And yeah, so you can also reach out to us directly here at Manifest. But we're going to give it maybe another minute. So we're going to start the conversation at 5:04 as people kind of log in and join this conversation.
Sweet deal.
All right.
This is definitely more chill than 3 a.m. phone calls Saturday and Sunday after this fee was announced.
Yeah, I definitely worked overtime. Maybe some of you guys have seen on our Instagram. I was definitely out at like 3 a.m, exiting the office, being like, yeah, there's a lot of calls and a lot of things that had to happen in a very short period of time. Yeah. Okay, so we're approaching that time in now. Okay, so thank you everyone for joining in. As a brief reminder again, so my name is Nicole Gunara. I'm the principal immigration attorney here at Manifest Law. We are a tech-forward, tech-centric firm that provides immigration legal services, both for individuals and companies alike. In terms of my background, I have been working in immigration for a while now. I would say I've been in immigration for about 7 years cumulatively. A lot of my work is in building futures, not only for individuals, but building futures in America for employees who are coming to the United States for multinational companies and emerging companies. I have here Roman Zelichenko, who is here to have a conversation with us regarding the H-1B policy updates and how it's going to impact HR leaders and global mobility specialists.
Awesome. Okay. I'll kick it off, Nicole. I'm going to ask you some questions. Then maybe I can offer some information. Then we're already seeing some questions coming in the comments. So please do ask us questions. We'll probably pause periodically and go through the comments and try to answer them. But first and foremost, I mean, everyone's talking about the H-1B, crisis or just changes, if you will. However, I think it makes sense off the top to maybe give a little bit of a summary about what's going on, what changes have been proposed, what sort of are people talking about with the H-1B visa. Nicole, can you share just kind of what's happening? What are people talking about?
So what everybody's talking about right now is essentially the government announcing this imposition, let's say, of $100,000 fee on individuals who have an H-1B petition. So when they first started, it was that general. They were like, yes, people on H-1Bs, we're going to be charging $100K fee to those employers to have these petitions done, adjudicated, and the like. And that happened on a Friday night. I believe that was like September 20th, right? Then they released the proclamation, the written words, all the attorneys, all the global mobility specialists, HR teams started scouring kind of word for word, like what they were saying. And as kind of the weekend went on from the 20th to the 21st, we got a few more clarifications, whether it was guidances from USCIS, CBP, and more interestingly enough, and I think it's so emblematic about where we are right now in 2025, social media posts from the government in terms of like official statements. And that created a situation where we did have more clarity on who is going to be charged this 100,000 and how they were going to do it. But even with that clarity, there's still areas of confusion because there were many agencies involved, many different stakeholders saying slightly different things. And being in this industry, being a lawyer, when we're trying to advise clients, words really do matter. So when there's a lot of different terms being thrown around by different agencies, leads to some level of confusion despite that level of clarity. So that's where we are today, which is some clarity, some areas of confusion.
What do you think are, so there are already questions coming in about sort of who is required to pay and when, when it first came out during the press conference, they said it would be an annual $100,000 fee. Then it changed to a one-time $100,000 fee. We're still unsure if it's one time over the course of 3 years, if it's over the course of the 6, or over the course of an entire person's H1. As far as I know, we're unclear. What clarity do you have right now as to when and where and how this $100,000 fee is applicable?
So I do think like one of the areas of clarity that I do have is that if you have a pending H-1B application, so let's say you filed a transfer or an extension prior to September 21st, 2025 at 12:01 a.m. EDT, they were very particular about that date and that time, right? You're okay in the sense that you're going to get this case ultimately adjudicated. And if that remains valid and you're able to work on it, then great. You're fine. If you have a currently valid visa stamp and you happen to be outside of the country based on your approved application for the H-1B, you can come back into the country even after that date had ticked on by, and you don't need to show this 100K fee being paid. Another area that I do know is that there is definitely going to be a strong impact for individuals who are enrolling in the upcoming H-1B lottery. Now, there is still one area of lack of clarification on whether or not if you win the lottery and you're in the US and you're not traveling, whether or not you have to pay that fee. But what I do know is that by that time, by that 2026 lottery, there is going to be way more details on how it's going to impact those bucket of individuals applying, because that is the strongest indicator of a new petition under those definitions. And I think like another thing that I wanted to mention is that it seems that H-1B1. So I got a lot of individuals asking me from Singapore who are saying like, does this apply to me? Does this not apply to me? I'm not sure. In reviewing like the proclamation and a lot of the details, even if the H-1B1 is substantially similar to the H-1B, and this also extends to the E3s for Australians who use similar mechanisms, those don't, these proclamations don't really apply to you because they're specifically citing to and mentioning the H-1B and not the provisions related to H-1B1s and E3s. So these are kind of like the facts that we do have, and where there's areas of uncertainty are a little bit wider, but I think it does give me a little bit of hope because I do think I have a direction of where this is all going to go towards.
So let's talk about that a little bit, because I think to your point, on the one hand, it's easy, or not easy, but it's a little bit more where you can confidently say, okay, here's what isn't going to happen. Like, here's who is not impacted. It's a little bit harder to say here's who for sure is impacted because we're continuing to figure that out. I know that you guys have, as an attorney, everyone has different approaches on how they advise clients. You mentioned to me previously to this conversation that you like to take a more conservative approach. You like to make sure that you're doing the absolute maximum that you can to make sure that your clients are not crossing any boundaries and potentially falling out of compliance. How do you view this right now? I mean, this is understandably gray. It's ever shifting. This may change. if someone's watching or listening to this in a week or 2 weeks, there may be some differences. But today, September 30th, 5:11 p.m. Eastern, what are some of your understandings on who this does impact, even if we're not 100% sure?
Right. So I do think it impacts any new employment applications after September 21st. So what does that even mean? So this is all stemming from the government definition of an H-1B renewal. So if I had to make this clear to listeners and people who are tuning in, essentially USCIS issued guidance, and they also issued these H-1B FAQs on their website to try to clarify some points. And one of the exemptions that they said, which is people who are exempted from this proclamation, they said H-1B renewals. So what does that mean? If you have been approved prior to September 21st, 2025, 12:01 a.m., let's say that you won the lottery last year or in this past kind of lottery season in 2025, you are technically exempted, but I want to hold it back a little bit, because what does renewal even mean, right? I don't think renewal is a legal term. When us attorneys are looking at the I-129 form, there isn't like a box that we mark that says H-1B renewal. So that raises the question that some of the viewers here are typing in, which is, does that apply if I'm changing employers? I've already been approved 2 years ago for one company, and now I want to change employers to a different company. Is that technically an H-1B renewal, yes or no? We don't really know that. We really don't. However, I do find it hard to believe that there's going to be a way for the government to assess those fees in this particular circumstance, unless there's going to be a change to the form in some way, because that definition of renewal is so expansive, right? But I digress. Maybe the other thing too is legal vulnerabilities, right? The more that they're impacting people in the past, right, retroactively, the more that they open up themselves to litigation. And is that going to be something that the government's willing to deal with if they can instead restrict it maybe to the newest batch of individuals seeking H-1Bs in the upcoming lottery? Because that's what the statements from the White House seem to be indicating, especially from the press secretary's statements in particular.
There's a really good question here from Ricky asking about concurrent H-1B filings by second employer. So concurrent H-1B filing, meaning you're already employed by somebody in H-1B, you're not leaving that job, but you're filing for a second concurrent job in an H-1B. Thoughts on whether or not that may fall under the scrutiny of this $100,000 fee?
So conservatively, I would say that there is an interpretation to argue that this is considered new employment, right? Because it's a different employer. And my worry is that you may not fall under that exemption of having an H-1B renewal being filed, right? However, at the same time, though, it is a separate box, Roman, from the new employment category when you take a look at the I-129 forms, right? So when you check off that box for concurrent employment and extension of status, it can feel like you can make the argument that it's considered a renewal. I am extending my stay in the United States based on a previously approved H-1B that now allows me to seek concurrent employment. That's how I would write it out. But I think what you touched upon earlier, which is the conservative interpretation, is that as of right now, there's no specific guidance on this. Like, I don't think the government has really addressed like a lot of these nuanced scenarios, and we won't actually really know until maybe a week from now. In being conservative, what I've advised a lot of clients and what I've advised a lot of individuals is that all of this just happened or came into effect on the 21st. And there are some employers that were willing to take the risk to file right after the 21st a change of employer application, or some of these examples of nuanced ones, which is concurrent employment and the like. They were able to get these cases receipted in. The fee guidances were not updated. Nobody was assessed a $100,000 fee. However, we won't know if any of these have been adjudicated until at least maybe a week to a week and a half from now, because even if they paid for premium processing, looking even at the current timelines for premium process cases, until they're adjudicated, it's not real, right? So once we hear anecdotally news of people getting approved for these transfers without being assessed this 100K fee, then it becomes a lot easier for us attorneys to answer questions like this, which is concurrent filing impacted, yes or no? Is transfers impacted, yes or no? Because again, they didn't define that exemption very clearly to us on what a renewal is.
Yeah, the other thing we might see is if there are any RFEs that are sent out for these cases that have been filed after the 21st, and what those RFEs say.
Right. And it's kind of crazy because one thing that we don't know, right, or what we really need to find out is, let's say this 100K fee comes to fruition, or let's say you have an employer who's ultimately willing to pay this fee. Even until today, we don't know where to make that payment. Right? We like, is it going to be like a commerce thing? Is it going to be on pay.gov? Like, I'm really trying to like imagine like what corporate credit card needs to come into existence for you to charge 100K straight up? Like, or is it that this was in line with, you know how on October 28th, they're changing how you can pay. So you can't use checks anymore. You need to use the credit card form, or they're introducing a new form known as the G1650 to do direct ACH debiting, right? So it's like you either have 100K in cash or a credit card that has enough of a bandwidth to charge that 100K. We don't actually know. We have no idea.
Maybe they'll have installments. Maybe we can do Klarna, 25K a month. I'm just kidding. I'm just kidding. Trying to make a little joke here.
Yeah.
So okay, great. I'm just looking through the questions here. I mean, we have a lot to cover, but I do love getting to questions. So there are folks talking about the fact that these H-1Bs have been filed, and so to your point, Nicole, we're just waiting to see what is going to happen with them. Okay, so let's talk about the HR side of things. All right, so we know that there's this fee. We know that there's a lot we don't know. We're going to have to wait for these cases that have been filed since the 21st, even via premium processing, to be approved, to see what sort of the reality is on the ground. Nevertheless, companies are already thinking ahead, of course, strategizing. I'm sure Manifest's clients have been coming to you and others on the team saying, what do we do? Right? How do we deal with this? How do we think about this going forward? And sure, you can say, let's wait, but I think there's probably some strategizing that has to go on. So what have you seen? And I'll share a little bit of what I've heard about how this has influenced the way companies are thinking about H-1Bs today.
Okay. I mean, I can definitely touch upon it because I did a lot of corporate meetings today in particular. So I think it's like great timing. So what we've been seeing is that there's a little bit of a holding pattern, right, to start, right? People are a little bit unsure because they're like, there's a lot of information still that needs to be clarified. But so far, we've paused a lot of our candidates who need this level of sponsorship, like an H-1B, until we know more. But then the next follow-up question immediately is, if let's say this does impact those candidates, the immediate conversation turns into what are the alternatives. So I was pleasantly surprised because the immediate gut reaction that people have in the general public is to panic, right? Now companies are never going to sponsor completely, right? They're never going to do it. And it is true that what this whole entire situation did was expose a level of vulnerability, right, to these corporations, where they're saying maybe we did over rely on the H-1B. We put too many eggs on the same basket. We have all of these employees, we have all of these pipelines that are coming in, and we focus too heavily on acquiring candidates who are only eligible for the H-1B, or we only believe are eligible for the H-1B. So I was really surprised that across the board in all of my corporate meetings today, that every single person or every single company was saying, what's the alternative? Because we do need to rely on foreign talent to some degree. Like, we do need to bring outside workers because of the high skill level that is needed, especially in the STEM realm. But talking into those alternatives, it's really figuring out short-term to long-term solutions. For the short-term solutions, there's a few different visas in the alphabet soup that we call immigration that people can definitely turn into, whether it's extraordinary ability visas or research scholar J1s and the like, to the more longer-term plays that are out there, which is, should we really start accelerating green card processes or thinking about the more, I wouldn't even say it's novel, but the other types of green card processes that could be out there outside of the traditional perm case, right? If anything, I really want to emphasize to everyone who's sitting here, right? Again, I'm pleasantly surprised by the fact that the companies are really willing to play ball in other categories, because there's a recognized need and demand for foreign talent to fill in these gaps. So even if the H-1B feels very constrained and very difficult, if a company is willing to explore those other avenues, and it seems that they are, regardless of scale, from the smallest startups to like the largest established multinationals, there is a will, there is a way.
Yeah, and there's actually a question here. I thought we can piggyback off of it. Ricky, who's been asking some really great questions on YouTube, asks a couple of things. Number one, should H-1B workers consider moving to an O-1? And can you self-petition? So maybe that's one question. We can maybe touch on that briefly. And then the other question is about the gold card, and not the EB-5, but specifically the gold card. So those are some of the alternative options. I mean, since you kind of brought them up and the question's been raised, how do you feel about some of these alternatives? And we'll go back to how this is going to impact corporates, but I do think this goes hand in hand. Corporates should think about some of these green card options. They should think about O-1s for their staff potentially. What's your thought on these various alternatives?
100%. I think corporates should really start investing their time in at least exploring and investigating how O-1s work and how they can support their staff. Because there's a lot of clever ways that you can utilize the O-1 to a company's benefit, right? Taking just one quick step back, right? I think it's important to focus on the language of what the government has been saying since they've dropped this proclamation, and even the conversation in the live stream. The Trump administration and the officials that were talking on the live stream, including President Trump himself, focused a lot on bringing the highest skilled talent, like extraordinary individuals to the United States. And that language is so important because it makes me feel that maybe they are pointing people towards the direction of the O-1. Maybe there's a little bit of a soft sell where it's imagine when it comes time for the midterms that they said, we brought in all these extraordinary ability individuals because they'll showcase the fact that there's a higher number of people applying for this category and a higher number of people moving on to the O-1 here in the United States. So I do think it's very much in line for companies to explore a visa that it seems to be ripe for cultivation, let's say, by the current administration and the rhetoric that's going out right now. But even setting that aside, when it comes to O-1 visas, there's so much that employers can do to support those processes. It might seem like a daunting task because if you talk to people, you might hear, well, it's a little bit more subjective than the H-1B, where you're checking off, does the job require a bachelor's degree? Does the person have the degree and or work equivalent to it, et cetera, and winning the lottery. With the O-1, it's like a rubric. You need to meet 3 categories out of a set definition of 6 to 7 criteria. And whether or not somebody meets can be questionable. However, if you take a look at the statistics behind it in terms of how many people get approved and what the approval rates are, my understanding is that they're above 90% even under this current administration so far. So it's actually very much an achievable visa, and there's so much that companies can do to support the, let's call it, generation of an O-1, especially if you're dealing with someone who's on OPT at the moment or STEM OPT. Transitioning to the O-1 might seem like a daunting task, but you as an employer can play a lot of roles, right, in terms of supporting that candidate towards building towards the O-1 in particular.
It's interesting that you brought this up. I was listening to a podcast today, and it was not an immigration lawyer or professional on it. It was a few business leaders, and they were talking about how they support this fee and that they think it's a great idea. And one of the things they were saying is, this fee is, the H-1B visa is used to bring, cheap labor. And that's the sort of politicized argument around cutting out the H-1B visa. And they basically said, look, if these companies are trying to hire the absolute best and brightest, the most skilled, extraordinary talent, they should be paying $100,000 for this H-1B. And it's interesting that you brought up language, because my first thought was they're using the language of an O-1 to describe what they believe are H-1B workers. And those are actually 2 separate visa types. The argument against the visa in total, in general, and for this fee is to say, well, should we be bringing if you're bringing the absolute biggest talent from around the world, companies should be paying $100,000, right? Which would make sense if the H-1B was meant to bring the most extraordinary folks ever. It is not. It is meant to bring people that have a skill that requires a bachelor's degree or more. That's it. They're obviously skilled, but they don't have to be at the very top of their field. And so I find it interesting that, the alternative, of course, is an O-1 for a lot of folks, but I think this is important because there's a lot of misinformation going on. I mean, that's why we're doing this webinar. There's a lot of misinformation going around, coming from, otherwise credible maybe sources, or at the very least, I should say influential sources, and then folks don't know what the truth is. So thank you for bringing that up and saying how, when the administration mentioned things like the words extraordinary, don't take that as a definition of what the H-1B is, but take it as a sign that maybe they want us to push towards the O-1, the EB-1, et cetera.
It's definitely an indicator of a strong push towards what they believe is a merit-based system, right? I think a lot of the underlying conversation relating to H-1Bs and maybe why the administration is pushing so hard against it is this idea that it's based on a lottery and like what to them feels like a very simplistic standard. So how do we make this a little bit more merit-based? What is the one thing that we can pull on? It's going to be two things. It's going to be wages and the ability to pay for that visa sponsorship, because those are the things that they can do to some degree.
A question for you, I mean, on that point, and sort of around who's able to pay, how do you see this impacting small companies versus large corporations?
I mean, I think for large corporations, it's a little bit of an easier pill to swallow, right? I think you've seen like some of the statements made by, Jensen Huang from NVIDIA, Sam Altman from OpenAI, where to them, it's like 100K for each individual, maybe ultimately a drop in the bucket given like their compensation, right? It's just going to be part of their total rewards package, right? In addition for hiring you as an engineer, we will cover this 100K cost. It's just another added benefit. For smaller companies, I think it's about maneuvering yourself through those alternatives. I do think that companies that are emerging who don't necessarily have like 100K to spend on these kinds of processes will need to think very differently in their approach on acquiring foreign talent. But I had some interesting feedback from a corporate client who is more of an emerging business. Like they have like really strong seed funding, but is it enough to qualify 100K? No. But they rethought kind of their understanding of this 100K fee instead of feeling that it's an upfront investment, right? Where it's $100,000 for an individual for that given time. It's divided over 3 years, because if you apply for an H-1B, you have a 3-year approval. So that's like about $33,000, $333 per year. And that, for some reason, made it easier for some STEM companies to accept that number, right? So instead of maybe budgeting for an entry-level engineer to be, let's say, $120,000 a year, it's now like $153,000 a year. Right. So there are some small companies that are willing, but it's all about that maneuvering of the alternative plans that actually have made emerging companies feel a little bit more calm about their ways of dealing with getting workers despite kind of everything that's happening right now.
Yeah. And, again, I think it'll be beneficial for, you and the team and myself, I suppose, to do another webinar maybe in a couple of weeks. 3 weeks, 4 weeks. Let's see how things are get updated, especially with any litigation that comes down the pike against this.
Right. And what's funny, and I want to share this with a lot of HR leaders and global mobility specialists who are here, or any of you who are employees or individuals who have a stake in everything that's going on right now, whether you're on an H-1B or you're best friends with like the HR leader at your company. I want to really remark on what they talked about as an exemption in the proclamation. So I think it's like section 1, item number 3. I think it's absolutely fascinating that the exemption doesn't cover just specific industries. So they said like industries or sectors, But the other or statement that was put in was companies. They could designate specific companies to be exempted from all of this. So they have this like mindset or this mind's eye of we need to have this carve out ability to say these companies are so critical to us that they're going to be exempted from all of this. Because I'm seeing a lot of questions on if I'm a physician, am I going to be exempted from this? Am I CAPA exempted from this? But actually, when I'm saying to people who are in these smaller companies, think about how you can group up with each other into associations. Like I like to think about like bigger strategies sometimes for these companies, which is that if you are one of many companies that are involved with a specific VC, right, or a group of VCs together, there's probably a potential reality where you can get to the negotiating table in front of your representative, in front of your senator, and say, we are such an impactful part of this industry. We are a larger grouping of people. Can we, as an association of companies, be exempted from this, right? And I'm trying to remember, like back in like the depths of my memory, Roman, remember when the small business associations or the SBAs were like exempted from like some of the NIE stuff during COVID? Like I just remember something about like being able to get appointments if you were part of like the SBA. So those things I think are very helpful for HR leaders to think about, which is tapping into our networks, tapping into the councils that we're a part of and associations that we can be involved with, getting into a good network so that if these things become reality where companies can be exempted and you just need to get into a negotiating position where you can also become exempted, that's very powerful.
Do you think there may be, and I mean, this is kind of speculation, but do you think there may be exemption based on company size, company revenue? I mean, you know, I think it would be against what this administration is trying to do, which is to, you know, build up American businesses. It would really hurt small American businesses who absolutely cannot afford $100,000. Do you foresee a world where if you're a small business, let's say you're not part of the SBA officially, but maybe you can prove it based on headcount, maybe you can prove it based on annual revenue, something like that? Do you foresee a world where that may be a possibility?
I can see a world of that, partially because of like a lot of the rhetoric and the conversations we have so far, right? I think they really want to target like the larger companies that focus on outsourcing H-1Bs, right? Yeah. Like, because I think they pointed to the fact that most H-1Bs are housed within like a small subset of employers, right? And in focusing on that, maybe you are correct that the direction that they're going to be walking towards is that we're going to, I wouldn't even say penalize, but it's like enforce this fee specifically for really large organizations that have this large number of H-1B workers, right? However, you know, I think it's definitely hard to say. I do think that ultimately what a lot of these roads are pointing towards is their ability to try to make the H-1B much more merit focused, right? And I don't know if these exemptions are going to cut across large swathes of individuals. It doesn't feel like it right now, but there is a clear reason why they're putting in these exemptions, and further to that, clear reasons why companies are also listed. And it's also very interesting that it's the Monday right after all of this dropped that you get these big statements from these big CEOs who probably may or may not have these exemptions in very critical specific industries.
Yeah, the politics is interwoven here. So just a quick recap, because I you know, want to talk a little bit about compliance. So there are some aspects of this H-1B fee proposal proclamation that we are certainly aware of and feel comfortable with, which is who it doesn't relate to. So as you mentioned, it doesn't relate to or doesn't apply for extensions of existing H-1Bs, folks who are in the country. We're not sure if it is valid in the what did we just say? The concurrent H-1B scenario. We're also not sure if there are a couple of people in the comments asking, you know, well, I was on an H-1B, I was let go. Maybe you're back in home country. Maybe you're still here on a B-1, B-2. You still have time to recapture. You have, you know, a year left on your H-1B. You can, in theory, apply. Is that considered new employment? Is it considered new H-1B? We're not sure about that either. So for the folks asking, yeah.
Yes, sorry, I actually wanted to add on to that, right? Because there's a really big question here that I'm seeing. And I really want to clarify this because a lot of people feel that because they have this, it no longer applies to them. It's having an I-140 approved, right? And breaking the 6-year limit. I see a lot of inquiries, or I see a main inquiry where an I-140 is different from an H-1B. The I-140 gives you the power to get out from the 6-year H-1B cap. Does that apply? The reality is that I don't even think the I-140 is part of this conversation, right? The proclamation doesn't say that just because you've been approved for a national interest waiver or you've been approved for a perm, that all of a sudden it doesn't apply to you. A lot of it is just, is your underlying status an H-1B? Is it that it's an H-1B petition, yes or no? So I just wanted to call that out really quickly.
Totally. And I imagine the fear there, as you said, for a traditional first H-1B holder, 3 years, and then you have an extension for 3 years, a company can think about it as a way to amortize that over 3 years. And so it's $33,000 a year. Okay, once you're past the 6 years and you're doing annual extensions through an approved I-140, is it every year? Is it applicable at all? We don't know. That's another one. As far as I know, that's another one we're not sure of.
Yeah, I don't think we're very sure. I am remiss to say that I've rarely seen like the 1-year extensions be utilized ever since the I-140s have premium processing for the AC-21 1-year extensions. I know people use them, but I am curious as well to see how that gets applied.
Yeah, because then that's an annual fee. I mean, truly. All right, let's talk a little bit about compliance, because on the one hand, it's easy for us to say we're not sure. Let's wait until things happen, but there are obviously cases still ongoing. We talked a little bit previously about Department of Labor at the same time on Friday released a memo, something called Project Firewall, where the DOL, which is separate from the Department of Homeland Security, right, which adjudicates cases, DOL, which is the Department of Labor, talked about kind of taking a tougher stance specifically on H-1B compliance. Just to share a couple of things from there. And this is very high level. I definitely recommend folks go to the DOL website and read the memo for themselves as well. But Project Firewall, they're really starting to target employers, or the idea is targeting employers who they believe misuse or otherwise mishandle the H-1B program. I mean, that's kind of the rhetoric around it. So the one interesting thing, which is similar, Nicole, to the idea of like certain companies being exempt, right? And what we saw coming out of the news, in the news there from various company leaders. Project Firewall allows the Secretary of Labor, an individual, to initiate investigations basically on their own, to say, I'm going to look into the H-1B compliance of a certain company for any reason I want, presumably, potentially. This Project Firewall also talked about strengthening interagency coordination. So basically, the DOL will have some additional leverage to work with Department of Justice, Equal Employment Opportunity Commission, USCIS, et cetera, potentially to investigate anything labor or wage related when it comes to the H-1B process. They also talked about prioritizing data sharing and proactive enforcement to detect fraud. So a lot of times for the H-1B, at least, the DOL kind of looks to individuals. We all know about the labor condition application, the LCA posting process, where a company has to notify affected workers that they're hiring a foreign national on H-1B or H-1B1 or E3. But for purposes of this conversation, H-1B visa, and there's some information there about what that person will be getting paid on an annual basis, where they're working, what their job title is, etc. And so if there are issues, individuals are able to call into the Department of Labor and basically file a complaint, right? If they believe there's fraud. Department of Labor comes in, they perform an audit or inspection of the public access file, issue or not, that's the process. Basically, this Project Firewall is saying that the Department of Labor, I guess, will be more proactive about, looking into when they believe there is fraud or abuse. How? As far as I know, we're unsure. What does that mean? What are they going to look at, to help them make that decision proactively? But that's something for folks to think about. So I wanted to just kind of mention those things because, interestingly, that was also published by the DOL on Friday, September 19th. But with this $100,000 fee, we didn't really look at that or think about it until the craziness of that weekend kind of died down a little bit. So Nicole, to you, I guess my questions are, from a compliance standpoint in general, do you think with what I just mentioned with the project firewall, with the $100,000 fee, we didn't touch on this, but with wage-based adjudication that is right now in a public comment period, what are some compliance, let's say, considerations that HR and in-house mobility folks should be thinking about or looking at, going forward?
Right. So again, I think it's funny because I just had this conversation with so many of the clients that I've been meeting, especially in the past few weeks, given everything that's happened. And I always encourage HR leaders and global mobility specialists to just take one step back, right? So before you start diving so deeply into how do I maintain a PAF file? How do I maintain all these things? Like, how do I get everything kind of like lined up? I say, like, we need to think about your guys' policies and processes and what it means to run global mobility at your company, right? Like, what are the fail safes and the checks and balances? Like, let's take a very simple example, right? Roman, you're very familiar with public access files, right? Let's say it's all done by one person at the company, right? You email, like us as the attorneys, we email all of that information, everything that needs to be put together for PAF. Technically, it is the company's responsibility to maintain that PAF and put it all together. But what if that person just chucks it away? Like, I, as an attorney, don't know where they put it, right? I can only tell them where to put it and how they put it together. And then they're supposed to maintain it. And then company moves a couple years here and there. They no longer have the physical, or they never saved it electronically, right? What was the issue there if something does happen, right? Is it that maybe we should have taken a step back and said, is it that there's a two-level system, right? Is there supposed to be a process built out that really checks off whether or not that process was actually completed internally and who has it? Is there a level of education that needed to be provided to the local HR leaders? So let's say there was a site visit, and the PAF file is actually held not necessarily at the place of employment, but the principal place of business. That could be another location, right? What is the process for that local HR representative to contact the shared services person who has it, right? So going back into like the original point about taking a step back, processes are equally as important, and the development of those fail-safe mechanisms is equally as important as the action of actually having all of these things together, right? And actually being proactive about those communication processes in addition to those fail-safe mechanisms is something that every single immigration partner and every single person who is touching H-1Bs and the like and anything related to the DOL needs to have an active conversation about, which is exactly what we've been doing all day today, which is let's take a step back and talk about your global mobility strategy and talk about your internal policies and processes, and what can I do as a firm to give you that education or to at least roll out policies that make it easy for your teams to understand and work cross-functionally.
And you're preaching to the choir there. I mean, look, when I was practicing, I was on the H-1B team, did high volume H-1Bs for our clients. That's why I literally left that practice to build labor lists. I mean, our tool automates the LCA and public access file process. And this is one of those instances, like during a chaotic time when suddenly there's a microscope, or I should say the H-1B is under a microscope. People, to your point, have to take a step back and understand what are our policies, what are our processes, and then I would argue and add, what are our tools, if any? Very often the answer is none. Our tools are an email and a printer and a thumbtack and a wall. And so one thing I would, it's a shameless plug, but this is my specialization, right? And right now my specialization, for better or worse, is like in the public discourse. People should consider, if they're holding on to paper public access files, that, to your point, someone could throw away, someone didn't do it correctly. It's hard to prove whether it's posted correctly or not, whether you're holding on to it correctly or not. Look at means of digitizing this process, because then that gives you more control over it. It decentralizes it away from one person, which is a big risk, and de-risks it by giving the company the ability to have multiple people hold on to this. So I think, to your point, they said H-1B compliance specifically, looking at the labor condition application process for you, looking at the PAF process for you as a company, What are you doing? What does that process look like? How are they interfacing with Manifest or whatever law firm they're working with vis-a-vis that process, looking at that and making sure that, they're buttoning up anything that perhaps in previous years they're like, yeah, whatever, we'll get to that someday. Well, sadly, unfortunately, someday is today.
Yeah.
A question for you and again, we don't know. We'll see what happens with the comment period. There's also compliance around wages. Any thoughts on H-1Bs going forward and wages, or honestly is the answer wait and see?
So it is true that there's a part of me that goes wait and see, but there was a reason why wage levels even existed, right? There's supposed to be like this, I wouldn't even say it's a calculation, but like an assessment. Like, what is a reasonable wage for this job that's being offered? There's a part of me that knows that for the longest time, especially for attorneys like myself, when we were looking at someone's role and when we were applying for like the H-1B, putting together the petition, yeah, if it meets level 1 at minimum and we can make the argument, then sure. But that wasn't necessarily like the spirit behind the wage levels, right? Wage level 1 is supposed to be for arguably entry level roles, right? Wage level 2 is for people with a little bit more experience. And I'm being very like general here. It's much more specific than that. But I do think moving forward, when it comes to filing new H-1Bs, personally, I think I would take a deeper look at making sure that whatever wage level that I'm providing to the government for that H-1B aligns with actually the role and the candidate that's going to be fulfilling that role. Because with everything that we're talking about, regardless of like DOL's kind of skin in the game for this entire process, or even from the USCIS perspective, I can see them focusing very heavily on prove to me why this wage level was the one that you put for this individual. Kind of reminds me of Trump 1.0, where they were pushing back on anyone with a wage level 1 or anyone with a bachelor's of business degree.
Yeah, that was a tough situation. So you think that wages are important to consider, but let's wait and see what happens during this 30-day comment period, and how the government comes out officially, right, with how they're going to be looking at wage levels going forward.
And I encourage a lot of you, whether it's through like a company perspective or yourself, right? Notice and comment is open for public comment, right? So if you have a comment and you want to be able to express your opinion or how you feel these things will impact your company or impact your industry, this is the time to do it, because that's the whole point of notice and comment. You make the comment and the government's supposed to have some reasonable response as to why they incorporated certain things that impact you and why they did change things according to what you said. But I would say that it's more likely that either things will remain the same, where they're going to just keep the proposal as is, or they're going to change things. Because I think what we need to definitely talk about is exactly what happened. Like, what was these proposals that are coming up? And I think that that's going to be important for today's topic, at least.
Yeah. Just to kind of reiterate that it is, I'm an immigrant to this country myself. What an unbelievable scenario, where the federal government issues a proposed policy on immigration, and I, as a regular civilian person, can go in and share my 2 cents publicly, and the government has to read it. So just to reiterate that for anyone watching, listening, especially if you have, if you're an in-house immigration or global mobility person and you have your thoughts on this, please go and leave your comment. The government will read it and will listen. And if enough people give enough good ideas, there may be positive changes. I've seen it happen in the past. One last question on compliance before we move on to kind of our last topic here about talent strategy and, kind of attracting people during this really weird, interesting time. What are mistakes that you actually see companies doing that you think, we mentioned take a step back, look at your policy, look at what your process looks like. Do you have standard operating procedures or not, et cetera? What are some of the mistakes that you're seeing people make? Because if you mention them, maybe someone watching or listening might say, actually, I've done that too. Let me go revisit that thing specifically.
So I do think it's a little bit tied to policies and procedures, but I think it's the lack of recognition of how many stakeholders actually touch immigration, right? So everybody from talent acquisition to total rewards to even executive compensation, I think of them as like this triangle with the generalists in the middle. They all, to some degree, have an interaction with immigration, but they don't talk to each other related to immigration. So how do I even express this as like an example? Let's say Total Rewards or executive compensation decides to promote someone, right? They're like, hey, you are a great candidate to go from a deputy CFO position to a CFO position, but we want you to be a CFO at a different company, right? This sounds like a great idea. Executive comp is happy. The HR leaders are happy because now you fulfilled this high level position. They're going to make this whole hoopla. But then nobody talked to global mobility, which is another team that's in there, or nobody talked to immigration because they didn't recognize the fact or were never told that immigration is a part of this person's journey, because that's not really seen. Like if you have a traditional HR platform, sometimes you just don't see that this person's an immigrant. They roll out the red carpet. They do all of the announcements only to find out that they needed an amendment. They needed to change certain things before you did this whole hoopla, and they're slotted into this whole new role. So that is the biggest mistake that I actually have seen that impacts larger companies and even emerging companies. People not talking to each other, right? People not recognizing the role that immigration can play in their employees. And when they don't talk to each other, it can have very significant ramifications, whether it's for that employee themselves who was so excited to get this big promotion, to be slotted to be the next, like, let's call it CFO of a company, right? But then wasn't able to do it, had to roll back the whole entire hoopla, had to have a conversation with the immigration teams that were involved. And then even worse, if the government, I wouldn't say had caught it, but if the government was involved later on into the process, how that would penalize the company in the future when it comes to applying for new visa categories or new applications moving forward.
Yeah, that's an unfortunate situation. I'll also add the maybe a little bit more of a nuanced and specific answer there. I mean, around what I know, which is the public access file. I see a lot of companies, and then by extension, oftentimes their law firms, are not double checking to make sure that the public access files are complete when there's, first of all, that they're created when they're supposed to be created, which is within 24 hours of posting the LCA notice, or and then second of all, whether or not they're completed and held on to in completed fashion. And so they only find out when the Department of Labor comes and does an audit. So I would say that right now it behooves companies to go and take a look at that, pull up your files, make sure everything's correct. If you need, get a checklist from your lawyer, outside counsel, maybe pay them to perform an audit. We did those when I was practicing. I think that's a really common mistake. Companies unsure of whether their paths are complete. And then the second one that I see is remote workers or hybrid workers. How are you ensuring that, the LCA is getting posted in a way that complies with that sort of a work environment? Again, from my perspective, it should be posted electronically. If you're posting it hard copy, make sure you're getting a confirmation that it's been, as silly as it sounds, printed and posted in their home, on their refrigerator, in their bathroom, on the mirror. Have them take a picture, have them attest to it in whatever you need, so that if the government comes, you got to make sure that you are, I think, cross your T's, dot your I's, buttoned up with this stuff. Because if they're proactively making a stance that they're taking a stance that they're going to kind of go hard on immigration compliance on on H-1B, I think it's really important to overdo it. Okay, we don't have a lot of time. Oh, go ahead.
We don't. Yeah, I was about to say, I make people take pictures.
Yeah, make them take pictures and send it, but make sure. And if you're an H-1B worker or if you're an HR mobility, that sounds silly, I know, but that's just where the government rules are. The last question, there was a question here about what about F1 OPT, STEM OPT. I was thinking about asking you, Nicole, to answer that more broadly, to say, with everything that's happening now, how can companies, specifically HR folks, talent acquisition, right, especially global talent acquisition, how can they stay relevant? How can they continue to entice students to come and work for them during or after their studies, et cetera, with everything that's happening right now?
I think it's like the soft sells, really enough. I don't think a student trying to kind of get their foot in the door is trying to say that you must do X, Y, and Z for me. Like, they usually don't have that kind of negotiating power. Maybe there are special students out there. And what I mean by the soft sell is there's so much that companies can do that doesn't really incur a significant cost that can make yourself much more attractive or relevant to a student. So let's say the company's approach is, I'm going to do maybe an O-1 towards the end of the STEM OPT period, right? They're going to work for you for at least 2 years, maybe going into that 3rd year, and then you'll transition them into an O-1. But when you transition to an O-1, instead of telling them that you're actually going to do that, you can say, I'm more than happy to get you the recommendation letters that you need in order to support an application like that. If you would like to do it on your own, I'm more than happy to provide, whether it's company redacted correspondence or more details and information internally, right, in order to get this case across the finish line. And those things are equally as powerful as you sitting there and saying that I'm going to pay you like 33K more, right? Because that support, even if it's a little bit, I keep on saying softer, but I think it's me trying to say that it's not really directly paying for a visa or going through things, can be extremely valuable. Because there are ways to kind of get O1s through your own means. There are ways to do a lot of processes through your own means, whether it's an EB1A or an EB2NIW where it's like self-petition, but that company support is extremely valuable, even if they're not paying for it or necessarily sponsoring for it.
Yeah, how do you answer the question about O1 sort of self-sponsorship versus company sponsorship? There was a question earlier, can you do it by yourself? What's the answer to that? Because some people are unsure about what the O1 actually entails.
So I will tell you that technically, if you look at the O1 FAQs, it says that you can't self-sponsor. But the way that I would think about it is that you can definitely pursue an agent petition, which is a little bit softer than having direct employment, so long as you can prove that you have an itinerary where you have a series of potential employers or employers who are interested in working with you, and you need like 1 or 2 in order to prove that over the next 3 years you have work for you. You can theoretically self-sponsor. And I know that that's such a vague term. I think what I'm trying to say is that it's easier to get someone to sign a letter or a series of correspondence that shows that there's work waiting for you versus I need you to sign these forms under penalty of perjury and affirm that you're definitely going to be sponsoring me and be responsible for me. Right?
Yeah.
2 very different conversations. And then there are ways for you to start your own company, have interest in that company, and have that be one of the many offers related to that agent petition. And that gives you a lot of flexibility. But I digress. It's not as simple as I'm just going to form an LLC company that's like a shell company and sponsor myself. It's a little bit more nuanced than that. But again, I think what I said earlier, if there's a will, there's a way. It's about being very creative and utilizing the O1 provisions to your benefit. And also having that really great conversation with the company to explain, I don't need your sponsorship. I just really need your support. I just need you to sign this deal memorandum or at least tell the government that you're going to be working with me at this wage rate.
Yeah, I think that messaging from companies is super underappreciated. I think companies underestimate how powerful it is to just say, we're here for you. We're here for you from an immigration standpoint, without having to lay out exactly what visa is or isn't, going to be paid for them or sponsored by them. And I really love what you said about companies saying, we will provide you with letters, we'll provide you maybe with some judging opportunity, whatever it might be to build that O1 a case or EB1. A lot of times that's free for a company to do. They just have to put a little process around it. Like you said, print out a redacted communication or have a letter signed by some managing director or whatever. It's free.
It is free. And also for emerging companies, sorry to like cut on that because I just think it's such a really great point. If you're approaching a startup and you're one of like 5 to 10 founding members, right? People who just started in the beginning, there's usually a lot of like press releases, a lot of like activities that are very public facing. It's very easy for the company to just slot you in for those, right? Mm-hmm. Get your name out there in that kind of context because you're part of like that building team. And those are things that can carry really strong weight as you try to approach the O1. And again, nothing that costs like an excessive amount of money.
Right. Exactly. Okay. Last question. We were supposed to have a Q&A at the end, but we had some really wonderful questions throughout, which is why we're still going through our presentation. Last question. If you're advising a chief human resources officer or somebody who's in charge of hiring and like looking at their people strategy going forward, And then taking into consideration what you've shared today, what we've talked about, sort of the uncertainty, how things are still unfolding with the H-1B, maybe these various alternative visa options, the O-1, the EB-1, the national interest waiver. What do you think HR leaders and mobility leaders should be like? What is this most important thing you think they should be thinking about? It could be concrete, it could be high level, but like if you were going to give them a takeaway, what would that be?
I will tell them not to give up on immigration. So I know that like a lot of times, and actually what I said earlier, which is like, I'm actually pleasantly surprised that people are open to the conversation, right? But sometimes when you hear all of these news and all of these things that just keep hammering over and over again, that feeling of, oh, it's going to get more difficult or it's going to be uncomfortable, right? I think that's so much in a vacuum, right? There are other opportunities out there. There are ways to kind of, let's call it, circumnavigate this entire like situation that is like revolving around the H-1Bs and the DOL and the like. I really believe that there is this whole alphabet soup of different options depending on what industry you're in, what you're willing to do, and how you want to restructure your programs. And it does take a little bit of work. Like I do think that finding the right firm to work with or finding the right, let's call it, thought partner to think this through is equally as important to creating those alternatives. But don't give up just because of everything that's happened. There's still like, we're like what, in week 2, right, Roman, on all of this happening? Yeah. Right? Yeah. It feels like a month already, but like we're only in week 2. So much can happen even from a month from now, 2 months from now. For all we know, in the finalities of all of this, it's only going to impact like if you're in this tiny box of individuals who were selected for the March 2026 lottery, that's all it's going to impact. And that is a very different scenario than what was explained on Friday night, that eventful night, I think on September 20th. Totally. September 19th?
19th, yeah. And one of the things I'll note, we didn't talk about it, but that's because the real answer is we don't know. There's within the industry, there's a lot of litigation that's being prepared, and there has been historically lawsuits filed against, frankly, all administrations, right? But certainly Trump 1.0. When the immigration bar felt that the government overstepped certain boundaries and lines. It's been successful many times, and so we're looking forward to seeing what litigation comes out this time, and obviously where it goes. Again, we didn't talk about it because it would be speculation. We don't want to, just predict. But that's something that people are talking to within the industry, and so for employers and frankly employees out there, just know that is already being considered. Okay, that was considered literally Saturday evening. People got together and said, all right, we have to put something together. So that's happening as well. So once that happens and we see how that plays out, it may change the tune, right? HR might feel different. Companies might feel different. I'll give you one anecdotal piece of news, and I didn't like this, not news, but an update. I talked to a law firm that said one of their clients after last Friday said, I'm out of the H-1B program. I'm done. And they don't file too many, maybe a dozen or so a year, but they said, I'm done. This is too much of a headache. And that was, they made a decision then and there. I'm, not judgmental of it. I do think maybe perhaps it was a little emotional because it's just so frustrating. You're already dealing with the lottery and other things, and now this. But to your point, and to kind of, I like to bring a little bit of peace and calm into this chaotic world of H-1Bs. Take a beat, take a breath. This is new. It's meant to turn everything upside down. The government is, trying to, let's just say, cause a little bit of unrest and lead to discussion around the H-1B. It will smooth out over time as things play out, as more clarification comes out, as litigation hopefully comes out. And so I would say for companies out there, don't make any major decisions too quickly. Let's see. It's been a week, as he said, a little bit more. Let's see how this plays out.
Yeah, 100%. I'm definitely in agreement with that. I think what I've been encouraging employers to think about is the fact of the matter, especially when you're in the STEM field, they feel it more than anyone that it is getting, as each year passes by, harder and harder to fight for talent. right, domestically. Roman, you and I have had like our own like personal conversations about how I feel about the STEM field as a whole, right, in the United States. I want to be clear that the government recognizes the issue. And part of the reason why they seem to be pushing this initiative is that, wait a second, our domestic STEM talent is actually struggling. We need companies to invest much more into training and like education initiatives domestically, because we really do struggle with STEM here in the United States, right? I love like quoting statistics and everything, but it's like always glaringly shocking to me that only 16% of American high school seniors are math proficient and interested in STEM. That's a very small percentage. And I think maybe what the government is intending to do, or what they're trying to do, is try to like push that statistic better, right? Have companies kind of go in, try to invest domestically here. However, at the end of the day, when you're feeling that pain of like those labor shortages that cannot be cured immediately just through education, I think companies, and this is more for the employee perspective, I think you would be pleasantly surprised at how much companies are really trying to look for those alternatives. Or even if they make those gut reaction calls like you just described, we're not doing H-1Bs anymore. They're going to immediately realize like, but wait a second, but we still have the shortage. We need these engineers, we need these data scientists and the like. Where are we going to get them other than to lean in on immigration?
Totally. And when things change, they'll probably come back and say, you know what, maybe let's do a couple.
Yeah.
And hopefully it'll go back to normal. I thank you to everybody. There's been so many great questions and comments. Where can people reach you, Nicole? I feel like I'm a podcast host right now, and it's a Manifest Law webinar. But where can people reach you, and how should they connect with your team?
Yeah, so people can reach out to us at our website at manifestlaw.com. Separately, we also have a wonderful inbox that you guys can email us with any questions or any concerns that you have. We really try to help as many people out as we can, and that would be at help, which is HELP as in Peter, at manifest, which is M as in Mary, A, N as in Nancy, IFEST law, LAW.com. So that's help at manifestlaw.com. Best way to reach us is definitely over email. And for any of you who are HR leaders or global mobility specialists, or anyone who's actually really tuning in, feel free to also reach out to me via LinkedIn. I'm pretty public over there. You can definitely add me, send me a few messages. I'm not going to lie to you, I do get a lot of messages, but I really do try to process every single one over time and try to answer everybody as quickly as I can.
I was going to plug your LinkedIn too. Yeah. And same for me, Roman Zelichenko on LinkedIn. If you have any questions about especially H-1B compliance as it relates to the LCA and public access file process, check me out there. Check out laborlist.io. Let's hope for, a little bit of calm and a little bit of the waves cooling down and everything. But we got to keep the people informed. We got to keep these conversations going. So it's been a pleasure to be on this webinar with you, Nicole. Thanks to everybody for your comments and questions. And I'm excited to hopefully collaborate more with Manifest in the future.
Yeah, thank you for being here, Roman, and thanks to everybody for joining this conversation today. But again, I know that we didn't get to everybody's questions, but don't hesitate to reach out and we'll see how we can help you or how we can work with you. Okay, all right, bye everyone. I'm going to end the stream.